Okay, so welcome back. After you've watched the last video, quickly recapping the history of the Commerce Clause that's in the United States Constitution, Article 1, Section 8, from the time of the Constitution until 1995, we're going to switch to when things really changed now in 1995 to the case of U.S. versus Lopez. Now, this case is the very first time since 1937 that the Supreme Court said no under the Commerce Clause. So from 1937 until 1995, every single law that Congress made and said, this is under the Commerce Clause, the Supreme Court said, yes, that's okay. So this is a very big change from letting Congress do whatever it wants as long as it does it under the Commerce Clause, okay? So what happened is that Congress made a law about guns in schools to try to tackle guns in schools nationwide. A 14-year-old girl was arrested for having a gun in school. And the Supreme Court said that Congress cannot regulate this, that Congress's law is unconstitutional. So looking through the case, the court says that Congress can regulate 3 areas in the Commerce Clause, okay? The first is channels of interstate commerce. So that means that Congress can regulate things like highways, rivers, okay? A channel of interstate commerce. The first thing that Congress can do is how commerce goes, how it travels. The second thing, according to the Lopez court, that Congress can regulate is persons, things, and instrumentalities in interstate commerce. So a person in interstate commerce would be a truck driver or a railroad conductor. A person or a thing in interstate commerce would be, the nuts that are getting shipped from New York to New Jersey, okay? And the instrumentalities would be the trains, the boats. So the second thing that Congress can regulate is the instrumentalities of interstate commerce, the people in interstate commerce, and the actual things in interstate commerce. And the third thing that the government can regulate is activities which have a substantial relationship in interstate commerce. Again, that's activities that have a substantial relationship in interstate commerce. So far, this seems like a summary of what we learned before. This matches up with the cases we've read. However, keep in mind that activities that have a substantial relationship to interstate commerce has been defined really broadly, such that everything Congress has done from 1937 until 1995 was approved. So an initial note is that sometimes federal laws and state laws can exist at the same time. And there's some areas where you can only have federal laws. So even though states can obviously regulate guns in schools, it doesn't mean that the federal government can't also regulate guns in schools. But Judge Rehnquist, writing from the majority of court, says that this is Congress going too far, that Congress is going to be able to regulate how you raise your kids and things like that if we let Congress do that. Rehnquist notes that Congress didn't have any findings, unlike those civil rights cases where Congress really had people come in and explain how segregation in the Jim Crow South was bad for business. No one explained how having guns in school is bad for business. But what the Supreme Court says is that this was an economic activity and it's therefore not commerce, okay? So this is going back to where we're looking at definitions of what commerce is and isn't, like how we did in the 1800s and early 1900s. Because again, from 1937 until 1995, we didn't say what is and isn't commerce. But we're going back now to definitions, and the majority in this case says this isn't economic. There's nothing economic about whether or not a girl has a gun in school. And therefore, there's no commerce here, and Congress can't do this. Now, there's a dissent to this case written by Justice Stevens, and he said that Congress can control the production of guns, so it should be able to control possession. So to flesh that argument out a little bit more, because Congress absolutely can control how guns are shipped across state lines, it would make sense that Congress also controls who does and doesn't have guns. Justice Souter also dissented, and he said that the court should show deference to Congress, which is since Congress is elected and all these elected representatives, the Supreme Court shouldn't be going and knocking down laws of Congress. And that if Congress thought that this was commerce, then the Supreme Court should trust this. So the next case is U.S. versus Morrison. And in U.S. versus Morrison, what we have is that there was a federal law that said you could sue in federal courts for gender-related violence. Basically, there was the idea that schools weren't doing enough to stop sexual assault on campuses, and so the federal government would do something where you could sue if you were sexually assaulted on a campus. What happened here in this case is that a student was raped by 2 football players, and the university refused to do anything, and the local police department refused to do anything. So she filed a law under this law that Congress had where she can sue her rapist in federal court for damages, the amount of money that he caused her in pain and suffering and emotional stress and physical damages. And again, in U.S. versus Morrison, a majority of the Supreme Court says, again, you can't regulate this, okay? This time, Congress had done a lot of findings on how it would affect commerce. Congress had called in experts, it had testimony, it had statistics about how violence against women in schools hurts the economy. It hurts the economy because fewer women want to go to college if they think they're going to be raped there and nothing is going to happen. So they don't get certain jobs, they don't become part of, the workforce, of the economic force, and that people don't want to go to certain colleges in different states if they think this is going to happen, and all sorts of things about how violence against women on college campuses does impact commerce. But the Supreme Court said no. The Supreme Court said that this is non-economic again, and they said it's local, because since this woman was raped and assaulted in a state and everything happened in one state, it's not interstate. Now again, this is really going back to how the Supreme Court used to look at things before 1937, right? We haven't heard the Supreme Court say in all these years this is a local activity. Even there, in the Wickard case, growing wheat that you ate yourself wasn't a local activity. So this is a really big change. So these 2 cases, Lopez and Morrison, are a giant change.